Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3062, United States of America versus Thomas Robertson, appellant. Mr. Cohn for the appellant, Mr. Pierce for the appellate.
Mr. Cohn, good morning.
The first issue I will focus on is the sentencing issue. And to step back for a second and to look at how the guidelines address obstruction of justice. If a person is under indictment and obstructs that proceeding, the guidelines provide in 3C1.2 a two-level enhancement. My research suggests the most common way of getting that enhancement in this district is by lying under oath during one's own. Then the guidelines step back and look more broadly at persons who have managed to get themselves prosecuted and convicted for obstruction of justice. And there, as the government points out at page 43 of the brief, there are a number of ways that one's obstruction can wind up being prosecuted, obstructing, falsifying papers relating to imported merchandise, obstructing an investigation under the Workforce Innovation and Opportunity Act, obstruction under 1505 of proceedings before departments and agencies. The government, perhaps tellingly, does not include in its list 18 USC 1503, which is the classic obstruction of the administration of justice statute. Within the way the guidelines work is within all those offenses, if one is convicted of obstructing the administration of justice, then there are two enhancements that apply. One, and by the way, all of this I think is pretty straightforward. One is for causing physical injury or threatening to cause physical injury to a person in order to obstruct the administration of justice, or causing property damage. And for that, the guidelines provide a severe 8-level enhancement. The guidelines also provide that if the offense was a 3-level enhancement, if the offense resulted in substantial interference with the administration of justice. So we have a subset within a subset, persons, and Mr. Robertson does not fall within the first subset. He was convicted of things like bringing a dangerous weapon to Capitol Hill, obstructing Congress under Section 15C2, which in the balance of my time, I'd like to get to that, the validity of that. But even assuming that's a valid conviction, there's no obstructing the administration of justice. And Judge McFadden wrote a very good opinion on that. And that's why we quoted it at length in our initial brief.
Did you make this argument in the court below, or is it forfeited, and do we have to look at this in the plain error review?
Yes, Your Honor. The argument was very much was made for sentencing. First, there was clearly an objection to this enhancement, to the 8-level and 3-level enhancement.
But not on this basis.
Well, the basis, I'll let the court be the judge. I mean, the transcript is right here. It's pages 16 through 20 of the sentencing hearing. The most telling words in a way, well, first of all, you have the defense counsel echoing in advance Judge McFadden, saying, Judge, we don't have an investigation here. We don't have our client interfering with an investigation. if one reads Judge McFadden's opinion, he rejects the cases that my colleague cited.
Can you tell
because
us
there was no investigation.
which of the appendices you're in when you're citing 16 to 20 of the sentencing transcript? Is that
That's probably going to be.
Robertson's
Yes, I'm sorry.
at A68 to 72?
There we go. Yes, exactly right. Thank you. Thank you. I'm more accustomed, I'll admit, to citing directly to the record, but yes, you're exactly right, Judge. 868, 869, just all the way through. And so echoing Judge McFadden, defense counsel says there's no investigation here. And that's what this enhancement is for. It's for interfering with an investigation. So you have the objection. Then the prosecutor says, defendant here is missing the mark. He was convicted of obstructing the election certification. And, summarize, that's what makes him subject to this. And so that's the erroneous argument in our view. And Judge Cooper adopts the erroneous view. He says, the court finds that the enhancement applies. The offense did result in a substantial interference given both the delay that the riot caused in the certification proceeding, which is the proceeding at issue, and the expenditure of substantial resources that was necessary to fix the damage that was done to the Capitol. That's what Judge Cooper said. And honestly, I have tremendous respect for Judge Cooper, but here he's completely wrong. It's not, the guidelines are not looking at the repair costs to the Capitol. The guidelines are looking, as defense counsel rightly pointed, to when a defendant or a person lies and causes the government to expend additional resources in order to uncover the truth and to pursue its investigation. That's what this guideline is directed at.
Could you move on to the other issue, please?
Yes, Your Honor. On this one, on the corruptly issue, I begin with unusual humility, which is that as rereading the Oliver North case before this case, before preparing for this, and then of course the Fisher decision, a lot has been written by eminent jurists about the meaning of the word corrupt. I've done my very best in my briefs to give my honest view of what this term means.
Do you think that corruptly can be proved by the use of unlawful means or only purpose?
It's the word unlawful that I stop at.
But you agree that it can be proved by means as well as purpose?
By means, yes, but I don't think it's the unlawfulness of the means that should be in the law.
But if you agree that it can be proved by unlawful means, then the additional element that you're proposing isn't necessary in every case.
Well, I'm not sure what additional element I'm proposing.
That there has to be a benefit to oneself or another.
That's right. No.
If you can prove it with means.
No. I don't think means alone what does it. I actually think, Judge, now that I'm clear about the direction you're taking, benefit plays a crucial role in understanding this.
Let me ask you, though, in the court below, the jury instruction your client requested said to act corruptly, the defendant must use unlawful means or have a wrongful or unlawful purpose, or both. And if means is one way of getting at this, then the element that you propose to add is not necessary.
Yes, Judge, but I am focused on what the statute requires, and the defendant, to his credit in his post-trial motion for a new trial, focused on the absence of any evidence of an unlawful advantage, of an additional, not unlawful, of an advantage that he had gotten. And I read the word advantage in his motion to be the equivalent of benefit, and it's often used interchangeably.
I understand that, but I think what I'm just trying to get at is that you took a position in the district court, and I'm asking you now, about whether corrupt means is a way of proving corruptly, or can it only be proved with corrupt purpose? And it seems to me that you made a concession that means is one way of getting at this. And the case law seems to indicate that means is a way of getting at this. And if means is a method of proving it, then the additional element you're proposing, which goes to benefit to another, that only goes to purpose. And so therefore, if means is a way of getting at this, what you're proposing is not necessary to prove corruptly in every case.
Let me answer your question. I hope I'm answering it correctly with the observations that both the majority in North and the dissent made. And they recognize the example of someone who calls a member of a congressional committee and says, listen, this is an improper investigation. You need to cut this out. Okay. The means there is not in and of itself going to tell us whether or not the corruptly prong of the mens rea satisfied.
That's true. And what Judge Silverman said in North was that if you have an unlawful means, that should be sufficient. But where the independent means are not criminal or unlawful, then you have to go to purpose.
He does say that, but he said it in dissent. And
correct.
Right. And
so I guess what we're trying to get at is whether means is a way of proving this as well as purpose. And it seems that they are two alternative ways of proving corruption.
Yes, but as I just said, I don't think alternative is the right way. And I especially do not agree with Judge Silverman's view that the independently unlawful means, a term that found itself in another recent decision of this court, is the right approach to addressing what corruptly means.
Let me ask you, Mr. Cohn, about the logic of the benefit limitation. Reading the discussion in North and some of the other cases, the concern, especially when we're talking about obstruction of Congress, is that there's a lot of, sort of hurly-burly in the political process where it's completely appropriate to try to influence or slow down or, change the priorities of what Congress is up to meet the needs of one's client, whether one's a lobbyist or, member of public who's seeking a particular kind of legislation or inquiry into a particular person or whatever. And all of that, much of that may be protected by the First Amendment, but all of it meets your ostensibly limiting, benefit for self or others definition. So if the major conundrum in interpreting corruptly is to make it meaningfully limiting when obstruction applies to Congress, it seems like your definition completely fails in that regard because the legitimate lobbying or demonstrating or the like usually yields a benefit.
At the risk of being the self-defensive, the word benefit comes from eminent jurists like Justice Scalia. So and it's repeated by a colleague of yours in the Fisher opinion at length.
You're talking about Judge Walker's
correct
concurrence, although he would find it met here. He would find it, or he suggests it may well be met here. Didn't have to go that far, but he said, if the effort of people like Mr. Robertson is, I want my preferred candidate to be in the White House, not the one who they're getting ready, whose election results they're getting ready to certify.
No, I understand, Judge. And as I say, I disagree with Judge Walker on that. Unfortunately, in this time, I have not gotten to the word dishonestly, which finds itself in Anderson again and again used. And indeed, in the Arthur Anderson case of the Supreme Court, and not just innocuously, it's the failure of the jury instruction to include the word dishonestly that was in the Fifth Circuit's pattern jury instructions that caused the conviction to be reversed in Anderson. So it's an important word.
What does dishonestly mean in this context? What does it add?
One thing it adds is to my answer to Judge Pillard, which is that, yes, benefit may not, in and of itself, in all cases, be a sufficient limiting rule. That is why we need to examine the dishonest purpose. So a person who, to use the example that is, I think, in the North case, a person who tells his client, you don't need to respond to this congressional investigation, just as innocuous advice. That's fine. But the person who knows that the congressional investigation, the lawyer, say, the lawyer who knows that this investigation actually is targeting him, and he would want to avoid that. Now, when he advises the client and fails, say, to disclose that this is the reason why he's giving this advice,
but what
now
if he
he's
does?
being dishonest.
Excuse
and
me,
getting,
but what if he does disclose it? What if he's honest about it and says, "Don't testify because it'll get me in trouble"? You're
Yes.
saying that's not obstruction?
It's still obstruction because
But that's
the
honest.
benefit.
But that's honest.
I understand, Your Honor. But realistically, good point. But it's a very good point, Your Honor.
It can't
But-
have to be dishonest, because if you're honestly corrupt, that's still obstruction.
Your Honor, it's telling to me that in the North case, when the majority opinion turned to what does corrupt mean, the first word it used was clandestinely creating a false chronology.
That's sufficient, but not necessary. I'm just saying dishonesty, it doesn't seem that that is a requirement, because you can be honestly corrupt, be completely forthcoming about it, and it's still obstruction. So it can't be that it has to be dishonest in every instance. It would be sufficient if it's dishonest, but it's not necessary.
I disagree, Your Honor. I think dishonesty is an essential aspect of distinguishing between people who are honest and forthright and are not trying to subvert the truth-finding process on the one hand, and those who are trying to subvert it. It's not an accident. It's in the Fifth Circuit's.
Okay, then if you could address the hypothetical then of the attorney that you posited, who honestly says to his client, "Don't testify at the hearing because then I will get in trouble." That in your view is not corruptly.
That's not our case, and it's an interesting.
It's a hypothetical that
Right.
addresses your claim that it has to be dishonest in every instance in order to be corrupt under this statute.
Yeah, I mean, just thinking out loud, I'd say he's not obstructing justice. He's told his client, and now the question, he's told his client his motive. And now if the client goes ahead and doesn't testify, is the lawyer obstructing justice? He's told his client right up front, it's because it's me. I'm not sure that amounts to obstruction of justice.
That seems untenable to me, counsel.
Is there, reading the cases, and I suppose, particularly when the phrase comes up, unlawful means or unlawful purpose, this feels like a very mercurial concept corruptly. And indeed, that judges and lawyers have treated it as if it can be met in different ways depending on the circumstances. That it's not like we're gonna, and I haven't seen a court, too bad, give one definition that always applies. Do you agree with that? That the minimum may depend a little bit on the nature of the charged corruption?
Judge, the way I try to address that in the supplemental brief is slightly differently. I note, and North is a good example, that in most cases, judges don't need to get into the meaning of the word corruptly because it's so implicit and inherent in the dishonesty that the dishonesty is so clear, the corruption is so clear from the core example of bribing someone to get a result, that it's not so much the mercurial aspect of the word, it's the fact that it's unnecessary to dwell on it, except in the type of hypothetical, candidly, that Judge Han was asking me, what is that corrupt or is it not? The situation, the unusual situation where a lawyer would say to his client. And so—
well, isn't the problem there that it's not honest corruption. It's an open corruption. In other words, he tells his client, I don't want you to show up because it might implicate me. That's not honestly corrupt. It's openly corrupt.
That's right, Judge. But it's not. But I have a trouble putting openly and corrupt together. To my mind, corruption is necessarily not open. So to say it's openly corrupt is a paradox at best. Those terms don't easily stay together. When one looks, I'm sure, in fact, at the decisions.
I think I could name several political figures who have been openly corrupt. I won't, but we'll disagree about that maybe.
Well, I'll just say
I think her question is a helpful one.
Mm.
I mean, that, well, I'm not sure. So someone who is openly corrupt may still be being dishonest, and therefore the statute still does work in the case of the hypothetical that Judge Pan poses, and therefore it may be in keeping with the language and purpose of the statute to include the requirement that you're pressing.
yes, Judge Pillard, and to turn back to Judge Pan's hypothetical, perhaps the jury would have to decide what dishonesty meant in that situation. Allow me to add, in the lead opinion in Fisher, one of the, I thought, extremely useful aspects of it was the summary of all the 1512C2 cases. And if you look at those the appellate cases, if you look at those, one after another involved concealment, clandestine activity, falsifying records. Each one of them, the word dishonestly, acting dishonestly.
Where are you looking?
I cited in the supplemental brief. It's a string cite that the lead opinion makes to all cases involving the affirmance of convictions under 18 U.S.C. 1512C2. I cited in the supplemental.
But to my mind, that again shows sufficiency, but not necessarily necessity. But I take your position to be that in all cases applying this statute, there has to be a corrupt purpose, and that purpose has to include trying to obtain a benefit for oneself or another. That's the only way to prove corruptly. That's your position, correct?
I think so, Your Honor. I think the way you put it, but again, no, to the extent that I think the word dishonestly, that kind of is a way that summarizes the cases that are in that long paragraph. That's the motive. That's what's animating these people, and that's what distinguishes them from, say, the hypothetical we were talking about.
But there doesn't seem to be a textual basis for what you're asking. You're saying that in all instances under this statute, corruptly has to include trying to obtain a benefit for oneself or another. What's the textual basis for that?
I'm not sure what you mean by textual basis.
The text just says corruptly.
Yes, it does. And we're trying our best to try to give meaning to that term, a meaning that's often hidden in the opinion because it's so implicit in the
Yes,
context.
and the only precedent that applies this standard is in the tax context. And it seems to me that it makes a lot more sense in that context because in tax law, you can make a mistake. And if you're not trying to benefit yourself, it's just kind of a mistake. It shouldn't be a crime. But if you do your taxes in a way that you benefit, you get more money back, then it makes sense that crosses the line to make something corrupt. It makes sense in that context. How does it make sense in this context?
The tangible benefit, how does the tangible benefit make sense? I think it makes sense in this example that we were talking about earlier that the court talks about in the North case. If a client comes to a lawyer, says, I've been asked to testify before.
No, I'm talking about this context, obstruction of an official proceeding. I'm saying it makes sense to import that requirement in the tax context because of the nature of tax law. tax laws are complicated. So in order for you to be criminally liable for doing your taxes wrong, you had to have been trying to get a benefit for yourself. But why does it make sense in an obstruction of an official proceeding context to require a benefit?
Fortunately, Judge Pan, I think on this aspect of the case, we agree. I don't look at tax law as the model here. I look at the North case, which involved interference with a congressional committee under 1505. I look at 1503, the administration of justice statute. It seems to me, and it's
But the North case didn't require the benefit. It was the Aguilar case that did.
That's right, Your Honor. But and Aguilar was also not a tax case.
But if you're relying on North, though, North doesn't say that that's a necessary requirement of corruption.
No, I understand, Your Honor. Where North was struggling with these terms, Fisher struggled with these terms, I'm struggling with these terms. We're all trying to give meaning to a word. Speaking of which, an important point that's
But wait, just going back to your reliance on North, I mean, this case seems very different from North, where the central issue in North was the admissibility or not of, or whether the jury should have been instructed that North believed himself to be authorized and whether evidence of authorization, because that would go to his understanding of what he was doing. But there's no question here, either as a matter of instruction or as a matter of record, the sufficiency of the evidence, that Mr. Robertson thought that he was doing something that was lawful. I mean, that's not his defense. He was convicted of using violence to overcome police, to storm and vandalize the Capitol, to enter areas en masse during the certification proceeding, acting in a manner that was calculated to intimidate lawmakers, to prevent them from fulfilling their duty. And so it just seems like the issue that was central in North is not helpful to your client.
Your Honor, the North case is cited at length in the Fisher decision. It's cited at length in the government's brief. So it seems like it's a useful poll here to look at. Allow me to add an important point, please, which is that, as I note in the brief, 1503, another obstruction statute, talks about corruptly or by force or threats of force. To my mind, what's going on there is that those concepts, although of equal moral culpability, corruptly, by force, by threats of force, are distinct ways of obstructing. And my client, which I think goes in part to your question, Judge Paul, is my client is being held accountable under 15C2 for basically using force and threatening physical injury. And that's a distinct way of prosecuting someone for obstruction that I don't understand the lead opinion to be necessarily endorsing, or at least endorsing to the point of reckless conduct. But the lead opinion talks about assaultive conduct. But my client was convicted of carrying a stick into the Capitol. And so are we going to stretch assaultive conduct to what I see as a reckless mindset? We're already going into the physical force, which is not in the statute, 15C12, and now we're going into reckless, bringing a stick. So
the lead opinion talks about independently unlawful conduct. And that is a concept that is also in the North opinion, also in Aguilar. And in Fisher, one of the independently unlawful conducts happened to be assaultive conduct. But there are other types of independently unlawful conduct, such as brandishing a stick, being disorderly, etc. And the case law and the lead opinion seems to agree that independently unlawful conduct is a basis for finding corruptly.
Right, and as you were disorderly, just picking up on that, Judge Pan, the difficulty I have with it is that, are we going to now say someone committed the misdemeanor of disorderly conduct, and that resulted in delaying the electoral count vote, and now they're subject to a 20-year maximum?
Well, no, there are other elements of the offense, but it might be sufficient to support corruptly, but you still have to meet other elements of the offense,
Well, let's
including, I
assume
think,
the
the
other.
nexus requirements and all the other things.
Yeah, but let's assume the others are met. Let's assume that his actions during the riot did contribute, Robertson's actions, to somehow delaying the electoral count so that that a jury could conclude that the act element was satisfied. Now are we going to say, well, and all you have to do is act disorderly in terms of your mental thing, which is because that's independently unlawful. You're now subject to a 20-year maximum sentence because you went and trespassed in Congress and acted in a disorderly manner. It seems to me, as Judge Katsas noted in dissent, this is a troublesome road to go down, that if you acted, his words, not mine, in an illegal way, in some small way, his words, then now you're subject to the 20-year maximum of this sentence, of this statute, I'm sorry. So,
Well, it is just a, oh, go ahead.
What about the subset if wrongful means is understood to at least encompass independently criminal means, or even knowingly engaging in independently criminal means, or even knowingly engaging in independently felonious means? It would seem that any of those definitions would be met by the evidence here would be sufficient to establish those.
unfortunately, yes. That's why I'm urging this court not to go down that road. And drafters of criminal law and interpreters of criminal law avoid saying your conduct was unlawful because it was felonious. That's a very, and in fact, by the way, that is a holding of the majority in the North case. We don't do that. So we have to find another way than saying your conduct was felonious, your conduct was unlawful, to define a crime.
I take your argument to be that because it is broad, we should interpret it to narrow it. But Congress can write a broad statute. Is the breadth in itself a reason for us to interpret this a certain way if we're not at the point of, I guess, unconstitutionally broad, which nobody's saying? And the fact that it's a 20-year maximum, that's just the maximum. Presumably, if this were to actually go to sentencing, a judge would take into account all the different factors, and it's very unlikely that anybody's going to get the maximum for some of the hypotheticals that you're positing.
Your Honor, so let me sure I understand the question. Is if the question is, did my client get the 20-year maximum? The answer,
No. My point is that you're arguing that we shouldn't subject people who their independently unlawful means is a misdemeanor, for example. They shouldn't be subjected to a 20-year maximum. Number one, I'm wondering, is breadth alone a reason to affect the way we interpret this? Because Congress can write a broad statute. And number two, we're just talking about a maximum sentence. It seems like you're assuming that everybody's getting 20 years for this, but whoever the sentencing judge is going to take into account all the factors under 3553, and presumably if all they did was act in a disorderly way, they're not getting 20 years. That's just the max.
Right. Let me then talk about breadth and talk about max.
Okay.
I do think that breadth is, the breadth is talked about in Fisher, it's talked about in North. To some extent, candidly, as we say in our supplemental brief, I think those concerns about breadth are a bit exaggerated, but the breadth is always a concern when one looks at the scope of a criminal statute. And as Judge Katsas noted, candidly, it seems like a really unlikely place for Congress to have placed a broad statute. Section 15C2 doesn't really seem to be aimed at catching a lot of wrongdoers. But so I think breadth should be a concern of this court, as it should be in interpreting all criminal statutes in a way. Now, turning to the max, my point on you're quite right, Judge Pan. As a realistic matter, do criminal defendants get the maximum sentence? No, ordinarily. But The bigger point, though, is as one steps back and looks at the severity of the crime, and it's difficult to measure the severity of the crime other than by looking at the statutory maximum. Then if the statutory maximum is a pretty objective measure of the gravity of the crime, the question then becomes, have you, by, as you were just saying, gone to Congress and engaged in disorderly conduct? Has the fact that that caused a delay in the Electoral College suddenly aggravated the severity of your conduct, the culpability, to the point where you are now subject to a statute with a 20-year maximum, and where, yes, if you misbehave in some ways, you might get that maximum?
All right. Any more questions? All right. We'll give you a couple of minutes and reply. Mr. Pierce.
Thank you.
Good morning. May it please the court, James Pierce, United States. A defendant who intentionally obstructs congressional proceeding by using independently unlawful means or animated by a corrupt purpose acts corruptly for purposes of Section 1512C2. Defendant Thomas Robertson acted corruptly through the intended and actual use of unlawful violence to obstruct the joint session on January 6th. The district court also correctly applied to sentencing enhancements under Section 2J 1.2, and this court should affirm. Now, I'd like to start with the corruptly issue, and I think it's useful to situate Section 1512C2's mens rea somewhat more broadly. It, in our view, comprises there's sort of three components. It's the defendant's intent to obstruct, that the defendant acted corruptly, and then the nexus to a pending or reasonably foreseeable official proceeding. Of course, what is presented here is just the corruptly question. As my introduction made clear, our view is consistent with the case law, with Judge Silverman's separate opinion in North, with what Congress itself did when it defined corruptly for purposes of Section 1505 in Section 1515B, is that a defendant can act corruptly either through the use of independently unlawful means or through corrupt purpose. And it's common ground with my friend on the other side that if we are in a world of corrupt purpose, there are various ways to get there, including using deceit or dishonesty, including seeking an unlawful advantage or benefit. I would actually add a couple of others that I think the case law includes, seeking to violate a legal duty. I think that one, for example, could deal with the hypothetical of the lawyer urging someone else to lie. In fact, I think there are two reasons why that would be corrupt. One is that's an act of corrupt persuasion that is independently criminalized under 1512B. But even if that weren't the case, it would be asking someone else to violate a legal duty. This court's decision in Morrison, I think a 1996 decision, talked about exhorting someone else to violate a legal duty. They're actually closely similar, wasn't a lawyer, but I think a criminal defendant asked someone else to lie. That's obstruction by asking someone else to violate a legal duty. In terms of, where's the line of independently criminal means? I think, Judge Tiller, your question highlights that certainly to resolve this case, all this court needs to say is independently felonious means is sufficient. I mean, here the defendant violated committed three felonies, criminal trespass with a dangerous weapon in a restricted area, disorderly and disruptive conduct with a dangerous weapon in a restricted area, and then an act of impeding or obstructing office.
Let me ask you this. What if you just indulge me a minute, what if we need to find more? What if we need to find what I think is a holding in Fisher? I think I'm a minority in that view, but that we need to find a benefit to the defendant or to another. Where is the evidence in this trial of a benefit either to Robertson or to another, and based, I guess, on Fracker's testimony?
So of course, we don't think that's necessary here, but
I realize that.
But I think it would be the evidence that the defendant's communications leading up to January 6th, making clear his views that the election was stolen and was fraudulent, rigged, and that he intended to be part of a counterinsurgency to try to stop that election result from being certified in some way, with the benefit being retaining in office his preferred political candidate. I read the concurring opinion in Fisher to suggest that would be the type of benefit that would meet this test. I think, I'm sorry.
I realize that.
I think Judge Pillard's concern, though, is quite apt here, which is that, frankly, in the context of congressional obstruction like we have here, and I read this to be, in part, Judge Katz's critique in Fisher, it gets somewhat complicated to conceptualize what a benefit might look like, and one could conceivably just describe as a benefit whatever it is one wants to accomplish. And I think that's one of the real vices in going down that route here. Again, and I think Judge Pan correctly identified at least what is our position, we don't disagree that that is a sufficient way in certain contexts to establish that someone has acted corruptly. I think the tax law, case law is the most clear example of that. But to my knowledge, there is not a single area of law that, whether we're talking about bribery, obstruction, that has used this unlawful benefit outside of the tax law context. I should walk that back. I think there's one Ninth Circuit case in a bribery case that talks about benefit. But by and large, when we're in the judicial context, many cases actually just say the intent to obstruct is enough to get you to corruptly.
But Mr. Pierce, just stepping back and thinking in the sort of common sense way, when you hear the term corruptly, how does that really apply here? It does seem like the core of corruptly is some kind of often secrecy, dishonesty, quid pro quo, behind the scenes. There's a sort of distortion, which the law in the sort of archaic terms somewhat unhelpfully refers to as like depraved or evil. This open, angry mob attacking the Capitol, corruption is not, if you're just talking to people in ordinary parlance, it doesn't really seem to fit. Can you respond sort of at that level of, common sense understanding and why using felonious means is a corruption?
So I do, and I want to resist one of the, I think, sort of asides you had in setting up that question, which is that the law unhelpfully refers to things like debased, evil, perverted. I think the core of what corruptly and corruption is, and it's not so much what I think, I mean, certainly the Supreme Court in Anderson says it, this court said it in Poindexter, is this idea of evil or wrongfulness, right? And I recognize that, as courts have said, and again, as this court certainly said in Poindexter, asking a jury just to say, is this wrongful, could conceivably lead to, hey, this is a little bit too open-ended. And I think that what is, in terms of, even when something is open, using independently unlawful means is here an effective proxy for what is wrongful in many respects. Now, there may be...
Do you think you can be openly corrupt?
Yes, I mean, and I think I heard Your Honor suggest you were aware of a number of politicians who are openly corrupt. But yes, I think it is possible to be openly corrupt. And I think the defendant was, as were many of the others involved in the violence on January 6th.
Is it, I mean, one of the things I've been wondering about is the, a non-quid pro quo, non-dishonest form of corruption is nonetheless sort of a twisting or a distortion of the way things are supposed to work. And in terms of thinking, again, and kind of how do ordinary people use the term corrupt, the corruption here could be, trying to distort, contort the certification process. Like, is that captured by your definition? Does that resonate with you?
I think that's correct. I believe we cite in our brief a Ninth Circuit case from 1949, Catrino, that talks about obstruction as sort of guarding against the criminal mind, the imagination of the criminal mind to obstruct in all sorts of different ways. And when Congress enacted 1512 back in 1982, the legislative history has sort of similar language. The idea being, yes, there is a distortion, a contortion of, statutorily, it has to be an official proceeding here. And in our view, certainly that was the January 6th certification proceeding. But I think the point is that what corruptly does, against the backdrop of what I just mentioned, is recognize the many ways in which people can go about doing that. They can go about doing it in the sort of the stealthy or sneaky ways that I think I heard my friend on the other side mention, and I think you ascribed to sort of the common idea that this is some sort of backroom unlawful dealing. But going and barging into Congress, just like if somebody came barging in here to stop this proceeding, that contorts or distorts, obstructs, impedes the official proceeding, and thus, would qualify it as corrupt.
Can I ask you about, we're here reviewing a denial of a motion for judgment of acquittal. Do you agree that our two alternatives are either to affirm or vacate the conviction?
I think there is some potential leeway to send it back to say the government's, the definition that the defendant sought below was so distinct from what they're asking for now that a retrial is potentially available. But generally, I do think the polls are the two that you described.
Okay. And the interplay between, there's no forfeiture when we're doing a sufficiency analysis. There's no forfeiture of the particular theory. We're just trying to correctly interpret the statute and then assess the sufficiency of the evidence against that interpretation.
That is my understanding of the Musacchio case, which this court then, I think, adopted in Hilly. Judge Henderson wrote separately there, perhaps identifying a different reading of it. But our view is, notwithstanding what is at a minimum forfeiture, arguably waiver by suggesting essentially the jury instruction that was supplied and then arguing for something else on appeal. I think sufficiency requires the court to interpret the statute, what the statute requires, and measure the evidence against that.
And can you just briefly state what you think is the narrowest holding that would sustain this judgment?
I think I started to set that up earlier, but I think if the court were to say independently felonious means used to obstruct an official proceeding is sufficient, and here the defendant used, I mentioned already, that at least the 3 felonies in service of his obstruction. That I think would be the narrowest. We think,
and the state of mind there is knowingly engaging in independently felonious means, or does it not matter as long as they're intending to do what they're doing and those are defined by the law as felonies?
The latter. So I think the state of mind, this is sort of why I started where I started in terms of the 3 components of mens rea. Certainly a defendant has to have the specific intent to obstruct the proceeding. In the course of that, if that person commits independently criminal conduct here, felonies, obviously we have to prove whatever the state of mind is for those particular felonies, but I don't think that corruptly adds some additional mens rea term to that independent finding of unlawfulness. I will say, though that is the narrowest holding, that nonetheless, this court will see cases that don't involve, in the January 6th context, that don't involve independently felonious, and I don't think there's anything in the word corruptly that would limit the word to that extent. I recognize, as Judge Katsas said in dissent, that there are potentially some category of cases, a protester in the gallery, that kind of thing, that could raise some questions. But there are ways to deal with those that, I think still preserve the core of what corruptly is. I mean, the court, as an example, could read in something like a public welfare offense in the Morissette case that says basically, look, things that don't damage property or cause injury to persons, and what Justice Jackson said, don't involve sort of aggressive invasions, things that aren't wrongful, right? To get back to the core of what corruptly does. Those are the kinds of things that might not be enough. Candidly, I don't think the court's going to see anything on January 6th that would fall into the public welfare category. And Judge Tiller, to your point, I don't think the court has to actually reach that and address that here. But I just want to sort of sketch out the government's position that although the narrowest holding would be independently felonious means, we don't think that that is all of what corruptly reaches.
Is 1752, is that a felony or misdemeanor, or could it be either?
It could be either. So 1752A, 1 through 5 sets out what are misdemeanors. Subsection B makes it into a felony if it involves the use or possession of a dangerous weapon. The defendant here possessed the large stick that the jury concluded was a dangerous weapon. That transformed 1752, in this context, the two charges, the trespass and the disorderly and disruptive conduct, into a felony offense.
Right. If there are more questions, thank you.
Does the court want to hear anything on sentencing? My time is up, so I'm happy to sit down. But I'd like to
hear on sentencing your position on that.
Okay. So at the first cut, the defendant forfeited this argument below, and thus this court's review is for plain error. The fact that there is, at least one judge, Judge McFadden, who has reached the conclusion that he has is counterposed by the district court's ruling below, as well as some others we cited in our brief. I think I added one supplemental authority that we think reaches the right conclusion. And so just as a matter of forfeiture and plain error review, we don't think there's a clear error that would warrant relief.
Why do you think we need to get to plain error? We're on the review of a judgment of acquittal, and we're looking at the sufficiency of the evidence under a properly charged jury.
I'm responding to the sentencing
enhancements. You're talking about the sentencing.
So I moved on to the sentencing enhancements.
Okay.
Not plain error with respect to the sufficiency.
And what about that sentencing colloquy that Mr. Cohn pointed to in the defendant's appendix? Court finds the enhancement applied. The offense did result in substantial interference. So there's clearly, it was raised and made an issue in that.
But what was raised was the factual challenge, right? So the two enhancements, the 8-level enhancement is for threatening or causing property damage or injury to person. And the second one is for substantial interference. And the argument on the first was, I didn't engage in threatening behavior that warrants this enhancement. And the second is, my conduct didn't contribute to a substantial interference. It was not the argument that even if you were to reach that factual matter, it doesn't matter because what was obstructed was not the administration of justice. It was, in fact, a congressional proceeding, whereas instead administration of justice has this narrower conception of a judicial proceeding. The way plain error works, right, is to ensure that arguments have a full airing below. The district court has a chance to resolve it. That didn't happen here. So that, in our view, is why that was not adequately preserved. Just to object is not enough. It's to lay out the theory, let the district court, consider that theory and land wherever the court would land.
All right. Thank you.
Thank you very much.
Mr. Cohn, why don't you take 2 minutes?
Just on the plain error point, first, Judge, the only case the government cites for plain error is a case where the defense counsel did not object at all. Okay, we clearly don't have that here. I don't agree with my esteemed adversary's reading of the sentencing transcript. Judge Pillard, you asked me for the page number of the lead opinion in Fisher that collected cases. It's pages 337 and 338.
Got it. Thanks. Sorry.
Of the opinion. And in those list of cases, which again I see as extremely useful, the The acts are lying in written responses to civil interrogatory questions, seeking a false alibi witness, attempting to orchestrate a grand jury witness's testimony.
Just going back to the plain error question, you said the only case the government cites is one in which there was no objection at all. Do you have any cases in which there was an objection, but on different legal grounds that we held preserved an objection to an enhancement on a different theory?
Offhand, I do not remember, but I'm happy to look at such a case, and if the court would like, I to submit it as something.
If you have such a case, it would help us to focus on the nature of the what's required to preserve.
Understood, Judge. I would only reiterate, if this is truly an issue, the statement of Judge Cooper at sentencing. I think the argument, Mr. Rollins, defense counsel, is that the thing that was interfered with was the certification of the vote. And there was both a delay in the certification of the riot and substantial costs were incurred to respond to the damage caused by the riot. It's the reason, as you well know, is the whole plain error is to make sure that the trial judge had a fair opportunity to address whether or not what the issue. And the trial judge understood, he's saying incorrectly, that the delay in certification of vote is an injury, is obstructing the administration of justice.
Well, that
He's simply wrong.
that prove the opposite? Because he's saying, obviously, there's an obstruction with the administration of justice. Here it's a certification, and nobody's saying, oh, judge, no, that's not covered.
But he's ruling at this point.
Right.
But that he's ruling in response to the trial counsel's argument that that this enhancement applies when there's, I'm quoting from trial counsel, a premature or improper termination of a felony investigation. And when someone has caused that investigation to spend more money, such as lying to officers or lying to the FBI, where they're committing perjury. Defense counsel is correctly saying, Judge, that's obstructing the administration of justice. That's not what my client was up to. That's what he's doing right there. And the government has to spend more money to kind of go around those lies. Defense counsel was exactly right. And he says, and he adds, helpfully for present purposes, and I think that's exactly what the enhancement applies to. And the judge on the same page rejects it says, counsel, Mr. Rollins, the argument is that the thing that was interfered with was the certification of the vote. The court is clearly rejecting this correct focus on whether or not an investigation was obstructed.
All right, if there are no more questions, Mr. Cohn, you were appointed by this court to represent your client, and we thank you for your very able assistance.
Thank you, Judge.
Case number 22-5313 et al. Adrian Da Costa et al. Appellants versus Immigration Investor Program Office et al. Mr. Bless for the Da Costa appellants, Mr. Banas for the Vega appellants, Mr. Goldsmith for the appellees.
All right, Mr. Bless, good morning.
May it please the court, my name is Jesse Bless, and I have the distinct honor of representing Adrian and Jade Da Costa in this matter. We'll be asking this court to reverse the decision of the district court and send it back for a decision on the pleadings. The merits. This is about the pleading. The pleadings that are under a notice requirement. And our complaint set forth a plausible case for unreasonable delay under the Administrative Procedure Act. And in fact, these cases are usually guided by a set of factors under this court's seminal decision in telecommunications called track. The district court found that we had satisfied 2 out of the relevant 5. We lost 3-2, I suppose, but the real error here was that the resolution of facts were decided against our case. I mean, against our side, against it. And it was resolved in favor of the moving party. And under a 12b6 standard, that's not appropriate. And in fact,
What facts do you think were resolved by the district court?
well, that they had been following a first in, first out methodology under their purported rule. So
Well, they took judicial notice of that, correct? And the district court's entitled to take judicial notice?
well, I don't know if you can take judicial notice of facts. He cited to a website that they had where they purport to present their rule of reason, their visa availability approach. We put forth evidence that they didn't follow it, and it's a resolution of fact. I mean, that first factor.
Well, whether they followed it or not, I think is a factual question. But if
that
it's
is
not
correct.
subject to question, I think that there's been a pretty longstanding practice of relying on public-facing agency websites as being not subject to reasonable dispute. And why is that subject to reasonable dispute if the agency is representing public on a public-facing website? This is how we do it. Why
Sure.
can't that be taken into account?
Sure. Let me break that down. And no one's, the first fact factor is really 2 parts. Is there a rule, and is there a rule that is reasonable?
Mhm.
And it's not reasonable if it's not being followed.
No, I understand if it's not being followed, I think you would have a factual issue. But
Right.
the rule of reason itself, which is based on the industry practice as explicated on their website, why can't the court take judicial notice of that? So that's not fact finding, that's taking judicial notice.
That's correct. And that's not what we're disputing. We're not disputing that they purported to go forward with a visa availability approach. Our facts were that they weren't following it and had not followed it in this instance.
And your facts, so you're saying as a matter of pleading, you've not asserted that they use first in, first out as applied to available, where there are available visas.
Right.
You assert that they've done something other than that in practice. And where specifically are the allegations of that?
Right. So those allegations were, I have it. I don't know if you want the sites.
I'd like the JA pages.
We only have appellants appendix, AP.
I have your appendix.
Yes. Yeah.
And and it has the complaint. And so I'm wondering which paragraphs of the complaint raise that.
Right. So if you go forward, so there was 92.
Paragraph 92,
Yes.
which says plaintiffs invested at least $500,000.
Sorry. Hold on. I apologize. Let me do a better job for you here. The 96, 97, 149, and 152.
They've approved thousands of later filed I-26s of other investors and including other investors in the same commercial enterprise.
Correct.
I guess the question is, how does that, so there may be later filed I-52 petitions as to which there are visa availabilities that don't apply to your client, and that would legitimately, according to their statement of what their policy is, that would be consistent with their policy.
So that would be inconsistent. If they had been approving later filed.
Well, they can be later filed. They're doing the FIFO, but as conditioned by available visas. And so if there are people in an area that there are more available visas, they're going to prioritize doing that over older where there may be fewer visas.
Sure. But in this instance, our visas were available. They were always available. And that's the distinction. So
I'm sorry, wouldn't you have to allege that other people from the same country who filed after your client were getting approved before your client? But you
Well,
didn't allege anything about what countries these other visas that were getting adjudicated first were coming from.
Let me just take a step back. So it's not just, it's rest of the world, and then there are only a couple backlogged countries. China, People's Republic of China, India. So if you're rest of the world, South Africa is rest of the world, you would be.
Is that, I'm sorry, is my understanding of what's on the website is that they look at the country's availability and they take that into account first, where is it available? And then within each country, they do a FIFO method.
It's really visa availability by the visa bulletin published by the Department of State each month. It's not by country. So it's not, if you were subject to it, and the reason there's backlogs is because there's a per country cap. But South Africa would not fall. In this entire proceeding, at the time they filed until today, except for that brief period in the lapse, there were visas available for Adrian DaCosta. They were never.
I had understood it the way Judge Pan describes it, that visas are made available by country. As you said, there's country caps. And so if the cap is met for a period, then they would halt. And it makes sense to jump over those people if there are visas available and yet assigned.
Yeah, no, it's not like Ireland, England, and so on and so forth. Is there visas available? Are you rest of the world, or are you subject to some type of country cap, or is there a backlog? It's not country by country.
But it seems that all you alleged was there are people who filed after us who got their visas adjudicated. And it seems like you would have to allege more to create an issue as to whether the agency is following its method.
We also alleged visas were available. And in fact, on a pleading basis, merely meeting fact factors 3 and 5, showing that the harms from the delay here. And keep in mind,
if we could just stick first with whether your allegations were sufficient. It just seems to me that you just alleging that other people who filed after you were getting adjudicated first would not be sufficient to create an issue as to whether the agency is following their rule of reason, which is this visa availability and then FIFO within that. Because you're saying they're not following, they're saying what their rule is and they're not following it.
Right.
But for you to sufficiently allege that they're not following it, it seems like you have to say more than people who filed after us are getting their visas. That's not enough. Because under this approach, it's not a strict FIFO approach.
For those that were visas available and they're supposed to be processing them first in, first out,
But among the available, though, they're different countries, and there might not be availability based on what country you're from.
Right. So for those that are available, like Mr. DaCosta, they were not following first in, first out.
It seems that you would have to allege that there are people from the same country who are getting.
Is that your position that there are people from South Africa who filed later who have gotten the visas?
We sit in the same commercial enterprise because we don't understand the government's rule of reason to ever do it based on nationality.
I'm confused by that. So you say it's certain capped countries and then the rest of the world? I thought there are only caps for certain places where this program is very popular?
Or by the nature of the immigrant visa allocation, you can only have 7% per country for all immigrant visas. So if you're subject to that cap, you're going to be placed in a backlog. And so there's backlogs in family and employment-based cases. So for an Indian national, for a Chinese national, where they may be coming close to the country cap, the Department of State, in its mystical powers, will come up with a monthly visa bulletin where they'll put an actual priority date, which is the date someone would file the petition. And anyone who filed later does not have a visa available. Anyone who filed before would have a visa available. They would be called current.
Counsel, the USCIS website says it's by country. It says USCIS will now first process petitions for investors for whom a visa is either now or soon will be available. The form captures your country of birth, which will be compared with Chart B, indicating visa availability for that country.
Right. I think what they mean, though, is sure, but they're not going to designate because there may be countries that become backlogged.
Correct.
Right. But if they're not backlogged, they'll be grouped together.
That's not on the website.
Yeah.
Well, I mean, I think what we're talking about, though, is the difficulty here in accepting taking judicial notice and saying, because Judge Boasberg did not say, well, you're from South Africa, so it doesn't matter. That wasn't his analysis.
He did say the analysis that you didn't sufficiently allege that they're not following their rule as to you.
Correct, but he never understood this visa availability approach, and certainly the government has not purported this visa availability approach this way, that it's by some type of country. And I think this.
Wait, I'm sorry. I thought that Judge Boasberg took judicial notice of the USCA's website, and this is what the website says by country. And so you're asserting that they're not following their purported rule of reason with respect to your client, but you haven't alleged that they haven't done that sufficiently, because the rule of reason that has been taken judicial notice of does this by country, and you have not alleged that people from the same country are being processed ahead of your client.
That was not even in their motion to dismiss.
So let me ask you, is your theory that countries that are approaching the cap or that have reached the cap, that they should be set aside, but that with respect to, as you say, rest of the world, that under the policy as they've stated it, that needs to be FIFO, that needs to be chronologically first in, first out, even if in their experience there are 6 applications a year from one country and 400 from another, and they might want to. You're saying they can't prioritize as between those.
No, in fact, there's this court's decision, Mina Z, XIE, that I recited in my reply brief. There's a specific order of consideration under the statute, 8 USC 1153 E1, that talks about the specific order of consideration that visas must be allocated, and it's by priority date. And so it cannot be by nationality. In fact, there's also a discrimination provision in the allocation of immigrant visas in the INA that would preclude the type of visa availability approach that apparently is on their website. They can't even do that under the law. That would be illegal, and I don't think they do. What they do is they take people where visas are available, and there's no rhyme or reason to it. And then the amicus that was submitted before this court showed they took 600 petitions that were filed after our plaintiffs and did it. And we're on the notice pleading here. This may be a merits decision, and in fact, if they had come back and said, listen, look at all the people who filed, you're well behind. That would be a merits question.
Whether you've stated a claim that the agency has not applied its rule to your client.
Right, but that's also not.
But it seems to me that in order for you to state a claim based on what our understanding of the rule is, based on the website, which was judicially noticed, is that they look at visa availability for that country, and then USCIS will use this information along with other factors to determine which should be processed first. So if you don't allege that there are other people from the same country who are processed before you, that is not on a FIFO basis, then you haven't stated a claim that the agency is not applying this program to your client.
Well, I don't think satisfying the first track factor is necessary to satisfy Rule 8A of the Federal Rules of Civil Procedure. That's not the essential elements of it.
Well, I mean, you keep referring to notice pleading, which harks back to Conley versus Gibson, but we're in the Twombly-Iqbal world. There has to be a plausibly pleaded basis, and it doesn't have to be, proof that would win at trial. But I think we're just trying to understand whether there is, and clearly the government will fill us in on what its theory is. But I had not understood the description you're giving us today to be your understanding of the policy based on your papers.
Well, I mean, it's not my understanding. It's really the Immigration and Nationality Act requirement. There is no way, and I don't understand their visa availability approach to designate it by nationality. And in fact, that would not be appropriate under the law in this court's decision in Mina Z. You can't do that. You have to take it by priority date unless you have no visas available because of the other competing provisions of law, which are the country caps. So there is no way in which you can start siloing people by country if there are visas available. They would go by
So
priority.
your view is that you must take by priority date globally unless and until the country cap is reached. And then you put that aside and you continue to take people by filing date globally.
And that was the purpose of the visa availability approach. I mean, let's not forget that they came up with that visa availability approach after our clients filed the petition because they wanted to reduce the processing time. And what they said was, it makes little sense for us to focus on cases and petitions where visas are not available because of the country backlog. So we're going to focus on those where visas are current and available. Makes sense. Okay? No one's disputing that. In fact, however, though, once you get into the queue where visas are available for the rest of the world, it must go by priority date. And that's not what happened. That's not what happened. And that's what we alleged. I mean, that's really in our pleading.
Just as a matter of sort of how the program works, the period when your petition is pending, the investment is tied up in the project, but the period of time during which it's tied up in the project is not counted against the minimum period of investment required to be eligible for the green card, right? So it's only is it 6 years that
So
one has to
you have to
maintain the investment?
You actually have to sustain your investment through the removal of your conditional residency or 2 years now. So that means after this 526 petition would be approved, let's say, then you have to file for an immigrant visa. Okay, then you have to come in on that immigrant visa, and then within, I guess, 90 days prior to the 2-year anniversary, you have to petition to remove the conditions because you're a conditional resident. You have to sustain your investment another 2 years. So we're talking. So that's why the delays are so impactful.
Am I misremembering that there's some 6-year commitment? I'm misremembering.
There's not a 6-year.
Okay.
You have to 10 years. You have to create 10 full-time jobs.
Right.
Yeah. No, I mean, you have to sustain your investment. And this is why.
But only 2 years after you get.
Well, this is the practical difficulty, whether you're a backlog or you're going on a border. Let's say they started going last in, first out. Your term of investment now has just been extended. Now, what is it, 60 months for a petition? It used to be 19 months when our clients filed. So that is added. That period of investment is added on. So this is why the delays are harmful. But I do want to just make one point. I didn't get, but track factors 3 and 5 in this case were found for our clients. The delays here had impacted their health and welfare. So track factors 3 and 5 in cases from appellate courts had found that standing alone was sufficient to get you past the pleading stage. And that's what we asked the courts. Give our clients a shot before the district court to go to summary judgment.
All right,
Thank you.
Mr. Banas.
Thank you, Your Honors, and may it please the court. My name is Brad Vance. I represent the Vegas in this case. Judge Pan, I want to try to answer your question. When you reference the website, you also reference Chart B. It said that on there. Chart B is something the State Department creates. So to see the contents of Chart B, you need to go to another website. You Google Visa Bulletin, it pops up real quickly. If you go to Chart B on the Visa Bulletin, you go to the right category for the employment-based fifth preference. You'll see the distinctions that my colleague was talking about. You'll see that the caps only apply to 2 countries currently in the EB-5 space, and that's the People's Republic of China and that's India. Those 2 countries do have their own separate columns in the Visa Bulletin, in Chart B and Chart A.
But I think aren't there also limits, like you could only have, but so many percentage of the visas can be from each country. So there's going to be a cap within each country as well.
Not on Chart B, Your Honor. They only identify the countries that have already hit the cap, okay, and that have this waiting line. So literally, the term for in the column that would apply to both my clients as well as my colleagues' clients is called Rest of the World. And again, if you go to the Visa Bulletin, see Chart A, Chart B, that's how it's done because they only identify priority dates that would be current per countries are backlogged. The EB-5, that's historically been China, and just in the last 6 months, India or so. And I think this whole discussion does get to the point that the lower court of this circuit is not applying Rule 12b-6 standards to unreasonable delay cases.
To answer me the same question that I asked of the DaCosta's counsel, where in your complaint do you allege, and I think you actually have something about political favoritism, like where do you allege departing from the stated approach?
Your Honor, I'm looking at JA 10 through 12. We have paragraph 51. They do not follow first in, first out. Paragraphs 55 through 59 allege visa availability approach is not a complete approach because really we don't know how they assign these cases, because A, the agencies never had to prove it.
Well,
And
for
B,
example, 51, they don't adjudicate forms on a first in, first out basis. That's completely conclusory. The plausible allegations to support that are.
Your Honor, if we continue to read the complaint, we learned that we allege that the agency expedited hundreds of people ahead of mine because they were in a project that was favored by the administration at that time.
Mm-hmm.
And again, we provided 200 pages of emails in response to our motion to dismiss that the court absolutely refused to look at. Those are absolutely relevant and available to look at a 12B6 stage.
Just tell me which pages to look.
It's around 218 in the joint appendix, Your Honor.
218, 218.
Yes, Your Honor. And what you're going to see is that through a FOIA, because again, we can't get past the motion to dismiss to get a record or discovery here, through a FOIA application that was returned after we filed this case, we see emails from the investor program office identifying this project, this expedite, describing it as problematic and trying to find a solution. And, it's all redacted, but they discuss litigation exposure. That is well beyond what we need to do at the Rule 12b6 stage. Your Honor, you said it best, Iqbal and Twombly. We live in that world, and unreasonable delay cases are not outside of that world. I'd point you to a case called Gonzalez in the Fourth Circuit and a case called Barrios Garcia in the Sixth Circuit. Admittedly, they do involve different immigration benefits, but this is not an immigration case. This is an unreasonable delay case, and unreasonable delay principles apply across the different immigration benefits.
Those are the cases that remanded for discovery.
Those are cases that said the government's motion to dismiss was improperly looked at because this is 12b6, and we don't know the facts yet, Your Honor. And the Sixth Circuit's case, if you read it through, you're going to see it rejects every argument that the government makes here because they treat these cases identically around the country. They file the same motion to dismiss, and that one was out of the Eastern District of Kentucky as they do here in D.C., as they do in Los Angeles, Your Honor. Because again, they use these what seem like natural ways to process applications, but they never have to prove it because once they lose a motion to dismiss, Your Honor, they settle the cases. So they're not ever forced to prove what their actual rule of reason is, whether they follow it, whether they provide favoritism to certain projects over others. And that's all we're asking for, Your Honor. I readily admit we could get through discovery and we could lose, but we don't even get that opportunity at this point, Your Honor. And the lower court is divided, and I understand the lower court in this particular district because of the unique nature of District of Columbia is overrun with these cases. But granting motions to dismiss and doing violence to Rule 12b6 principles that no one disputes is not the way to handle it, Your Honor. I would point in the Sixth Circuit and in the Fourth Circuit, they haven't all of a sudden been overrun by unreasonable delay cases in the immigration context simply because those courts have said motions to dismiss in this context are inappropriate. And so for that reason, I think, Judge Pillard, I think you're doing exactly right. We go to the four corners of the complaint. We give every specific non-conclusory allegation the presumption of truth. We assume it's accurate. And to the extent there's a dispute between something the government has averred in their motion to dismiss and our fact, that fact of dispute precludes a finding, or precludes granting the motion to dismiss. Again, these are not disputed legal principles we're talking about. This is Iqbal and Twombly. This court and the lower court apply Rule 12b6 consistently in every other brand of cases except unreasonable delay cases in the immigration context. And I find it interesting that when you look at unreasonable delay cases out of the District of Columbia for, say, the Bureau of Indian Appeals, there's two that the government always cites. One's called Mashpee and one's called Mukweka. Those cases went to discovery. They didn't lose the motion to dismiss stage. They lost its summary judgment. The agencies in those cases had to prove the facts. And at the motion to dismiss stage, it's a very
it depends on the complaint, right? So it's fact specific. Now, on the blanket expedites to new commercial enterprises, you haven't alleged that has happened since your clients filed their petition. You cite something that happened before under a prior administration. So why is that enough?
Your Honor, it went through 2020. That's well after my client filed. My client filed in November of 2019, the two that are still accurate. And they didn't cancel until 2020, until...
Cancel what?
They didn't cancel this expedite, Your Honor, until the new administration took over in 2022. And so yes, they suffered. And it's 271 at least immigrants that were decided ahead of time in about 90 days. That was the average the government admits. That's, if it really does take an adjudicator 8.6 hours, that's pushing people back by a year, essentially. And that's inappropriate here. Now,
did you allege that timing overlap? Where in your complaint is that?
Well, Your Honor,
expedites. Yeah.
I would point you, it's in that paragraph 67 through 71, and then at the end of paragraphs 145 through 156, Your Honor. And again, keep in mind, when I alleged this and filed this complaint, Your Honor, we didn't have that FOIA yet. And the government was claiming, no, we don't do blanket expedites. This isn't something that we do. We would never do that. And the website that you see, Your Honor, they've all been taken down because those folks are now concerned about it. But this gave not only that regional center a significant commercial advantage, which is what the adjudicators recognized the problem, but it also delayed my clients and delayed most folks after them. And Your Honor, I just want to point out one last thing. I know my time is up, but the track factor 4, we've been focused on 1 for most of the time, but track factor 4 seems to be, let's put it this way, I just lost a motion to dismiss in Texas solely on the basis of track factor 4. And this court is uniquely suited to discuss it because around the country, on the different circuits, they look to the DC for, expertise in administrative law, which I think is appropriate. And they cite this case called the Mashpee Tribe. And Mashpee Tribe, generally, when the government cites it, stands for the proposition that if you're going to get pushed to the front of a quote line, that mandamus shouldn't lie, or an unreasonable case shouldn't lie, and you can lose exclusively on that. This court really needs to take that on and discuss it and explain whether it applies in an immigration context, simply because in that case, we were talking about an administrative process that can only be done consecutive. It was an undisputed fact that literally all of the agency's resources went to one application at a time. And if they moved to that second application, all of those resources would be on the second application. And for that reason, there were only 10 applications pending. And if they moved them, you could see it was a discernible.
So what's your answer here to why it wouldn't be line jumping for the court to grant relief to your clients?
Because, Your Honor, there's no line. The agency can grant hundreds of these a week, if not more than that.
I thought the whole position was there is a line, but that they're taking people out of line.
Your Honor, we allege multiple times there's no line. I think the line is a very powerful metaphor. But
I thought that FIFO, the whole concept of filing date being the sequence in which the agency is supposed to process these applications, that is a line, no?
Your Honor, I don't think that holds up.
So they're claiming that but not doing it? Or you're saying they're not even claiming that?
They claim first in, first out in everything.
Yeah, and so that is a line. And you're saying, well, they're not doing that.
Well,
so they should just throw it in the gutter? You just totally lost me.
That's fair. I'm very good at losing people. Let's describe the line. Okay, let's talk about the line. The line is at least 26 adjudicators wide because.
Okay, so there are 26 lines.
Okay, there's 26 lines.
Or there's one line like you do when you're going to TSA, you're in one line and then you go to the next available.
That's a great question to fact, Your Honor. I would love to know how it actually works.
Mm-hmm.
But there's 26 at least, right?
Mm-hmm.
And again, this is all now guesswork because we don't know, because the reason, their visa availability approach, they don't talk about how they actually assign the cases for adjudication. They only talk about things in the abstract. But some of them are deciding, it's supposed to be prioritized that if they've already made a decision on a regional center, that could be 5 applicants associated with that. That could be 500 applicants associated with that. Right.
I think you said they've now disclaimed that because they realized they didn't have authority for that to expedite regional centers. No.
I'm not talking about expediting, Your Honor.
Okay.
That's a special line. I guess that's the.
Okay. So when you talk about decision on a regional center, how does that fit into the rule of reason that we look first in, first out?
I think that's a question for the government because I don't know the answer. My best guess, because again, we haven't gotten to discovery, we haven't got to test their factual averments under oath. A regional center, no one invests in a regional center. Regional center partners up with businesses. Okay, actually, I stayed in a hotel that was built with EB5 money last night. So the Marriott, right? Marriott is the new commercial enterprise, and that's where the foreign nationals put their money. Now that Marriott has to associate with a regional center, an organization that's been designated and certified by USCIS to help promote these projects and grow them and have multi-million-dollar investments rather than just smaller ones. So my understanding of the visa availability approach is if we have already reviewed the fundamentals of that project associated with that regional center, and there's 45 applications because it was a $20 million project, then we're going to prioritize that because we've already done a lot of the heavy lifting. We've already looked and determined whether the job creation was there, whether the econometric analysis was appropriate, and now we're just going to look at your source of funds. And so that plays into this assignment versus just passing them through, Your Honor. We don't know how that works. Those 26 adjudicators, and by the way, it could be more, Your Honor, right? They have 30-some adjudicators just for fraud.
There's a process to apply for expediting. Are you saying this is separate and apart from the
Your Honor,
expedition?
that's exactly right. If you're an individual and you have humanitarian bases and you say, please expedite, sure. And that's available to all visa petitions.
So the basis for the expediting process is an individual thing
Typically.
based on your hardships.
That's right, Your Honor.
I see.
The expedite here.
So a blanket expedite for a project is a separate thing, and your position is that there's no part of the rule of reason that addresses that.
That's exactly right, Your Honor. And just to be very specific, what was expedited here was at that time called a Form I-924. And a Form I-924 was what a regional center files to get kind of pre-approval for one of their projects. The pre-approval meaning, we agree with the job creation. We agree with, the econometric analyses. And then these regional centers that go out and sell these securities and say, look, the government's already approved our exemplar. And so come join us. And you can imagine it's a very good marketing technique. We've been pre-approved, show your money came legally, and then you'll get a decision. So what was approved in the Tryon project was that, the Form I-924. Yet they decided to adjudicate in an expeditious way 271 individual applications, totally different. None of those individuals had to say, hey, my mother's dying in the United States. I would like to come stay with her and see her through the end of her life. I can only do that with an immigrant.
And you're saying that they took them out of line. It wasn't FIFO for those people based on their country.
Based on those emails, Your Honor, the government says their average time was 3.3 months, while they were reporting on the public website 62 months, Your Honor. And this is our problem with public websites and taking judicial notice. We've alleged disputes of fact, and the lower courts just ignore them. And they say, well, it's on the CIS website, so it's gospel. And I would suggest that through our complaint, because that's what we're limited to, that in the attachments, that you'll see, we allege that those are all incorrect and provide substantial and corroborating evidence for that.
So I guess then, just in terms of the way you plead this, I'm looking at parts of your complaint. It seems like you would have to plead that they have blanket expedites and there were ones that affected your clients.
Which we did, Your Honor. And
It looks kind of general to me, what you said.
We plead they're illegal. We plead it's a product of favoritism because there's no mechanism under the statute, regulations, or policies to agree to adjudicate an entire 271 people because half of those people haven't even been solicited or signed up yet when the expedite was granted.
And you're looking now at paragraph
146, I guess, that's what I'm looking at. That upon
Yes.
information and belief accorded significant processing time benefits to certain projects, even though not authorized to be a regulation. And then see, for example, this project.
Correct, Your Honor. And again, I would urge you to look at the documents attached to my response to the motion to dismiss, because again, if we went for discovery, these are the things I would get. And I'd be able to show, or at least I'd be able to present to the court, hey, here's what's actually going on. Now make a judgment on summary judgment. Because the way we get rid of the flood of cases on delays in the lower courts is decisions on summary judgment, so that we have something that as a matter of law, I can tell my client, well, In this situation, we can't do that. Otherwise, if we keep this motion to dismiss rule, this low risk, high delay strategy from the government side, these cases are going to continue to come in and they're continue to create significant splits and do violence to undisputed Rule 12 principles. And for that reason, Your Honor, we would ask that you vacate the lower court and allow us to finish the case.
Just one point of information, when you're talking about these blanket expedites, is that the same as the exemplar approval that you allege, or is that a different thing?
Totally different, Your Honor. An exemplar is something that's been in the industry for the last 10 years, and even the new law that just got passed March of last year codified that. And so exemplars are just a separate form that basically allow a regional center in the project to get certainty and provide certainty to their potential investors. Because, Judge Blard, as you noted, these folks are investing a significant amount of money and creating a significant number of jobs. And when they come into this and they say, okay, I'm going to put up my, nowadays it's $800,000. What's it going to look like? And you have to say, well, I think under the system, you would say, well, let's give it a year to get approved. Then you have 2 years in your conditional status. And then we apply for your conditional status, you can get your money back after that decision. So you're looking at probably tying up your money, let's say 3 to 5 years. Right now, their money is tied up for 5 years before any of that even starts, Your Honor. And so now you have these new issues that are being caused by this delay of this whole concept of it's called redeployment, where they have to keep their money at risk. So the financiers who accepted their money originally, the project's over, the hotel's built. So now they have to keep their money at risk in something else. So they take the money and they redeploy it into something else that the original investor never knew about or could know about, because these processing times have really done a number on the program.
The exemplar approval is a tool that potentially a regional center that is trying to administer blanket expedites might use? No.
So when you say blanket expedites, to my knowledge,
I think, yeah.
To my knowledge, there's only ever been one, and you're looking at it. I don't know.
It says, though, that it's a rural set aside. Is there a different statute that applies to this particular blanket expedite because it's a rural?
No statute, regulation, or policy tells you how to request a blanket expedite because it's something that's made up.
No, but it says the law creates new EB-5 visa categories, including rural, subject to a different queue. So if this expedite is subject to a different queue, then your client was not.
No, Your Honor. The rural set-asides were only enacted in March 15th of 2022 under the EB-5 Reform and Integrity Act.
But I'm just going by what's cited in your complaint, and this website says it's a separate queue from what your clients are in. So this wouldn't support.
I'm sorry.
I just clicked on the link in your complaint.
Oh,
So
okay.
the ebfivefast.com, and it says it's a different queue. So
That's
your
because-
client's not affected by this.
That's because the website link you clicked on has been changed, because what you're looking at could not have been in place in 2019 when we filed. And the blanket expedite, you're not going to find it anywhere.
So I guess where I am is I think you could theoretically state a claim if you have actually alleged that there are blanket expedites that are hurting your clients, but I don't see it on the face of your complaint, and what you've cited doesn't support it. So I'm just trying to see if you've actually alleged facts that would support that theory, which I think is a valid theory, but I don't see the facts.
Your Honor, I would say, again, we're dealing with the problem of delay. The EB-5 FAST website has been changed. The pictures you see came from a website that goes back in time on the internet and gets screenshots because they changed it.
So what am I supposed to do here? This is what you've cited. I don't see in your complaint the facts to support your theory.
We certainly.
So I guess you lose because the face of your complaint doesn't support it.
Your Honor, we allege that this delayed our clients. We allege that the agency's.
But you have to support that with facts. Where are the facts?
Your Honor, we don't have to win.
No, you don't have to win, but it has to be plausible. You've stated a theory. You have to have some factual allegations to support it.
Your Honor, first off, I would say that the court below didn't even look at all of our factual allegations. It ignored half of them. That's the first thing. The second thing is we have to give our factual allegations the benefit of the doubt, and even if they're doubtful, assume they're true. And so when we allege, they decided 271 people from 2017 to 2021.
I'm just looking at your complaint, and I don't see the facts. That's all I'm saying.
I understand, Your Honor, and I do believe that the complaint speaks for itself. I do think that this court can review the documents attached to the motion to dismiss because they're referenced by, incorporated by reference in the complaint. And for that reason, we think that this court should force the lower courts here to actually apply Rule 12b-6. Thank you.
I just have one more question. Health and welfare, you allege that the delay affects health and welfare. It's clear that it affects the tying up of the economic resources, but isn't that economic harm, not health and welfare?
Your Honor, I think that, yes, tying up money is economic, but I think that track factor is kind of a duality. Does the benefit that's being delayed impact the person's health and welfare, or is it an economic regulation? I think it's very stark. And I think here, the significant imposition on their daily lives is what we allege. They're just being deprived of the ability to immigrate to the United States for years and years. And imagine getting passing the bar, right? And then the state saying, oh, we'll get you your certificate to practice here in a second, and then waiting 4 years. During that 4 years, sure, you're going to get it eventually, but your life would be on hold. And that's the hardship they're suffering. And that goes to their health and welfare, not their ability to go earn money as a lawyer, right? In that metaphor.
Yeah, although that theory seems very broad in the sense that it's difficult to wait for any important benefit. And so that track factor would basically virtually always be met. Prolonged uncertainty about a significant benefit.
I think, Your Honor, that it will go to the weight of that factor. I think is this economic or is this health and welfare? This is health and welfare, but given this particular context, this specific case, it doesn't weigh that heavily in their favor, Your Honor. I would just point you again to the Barrios case, which my colleague cited, where they say, yeah, alleging that you have legal disabilities under the law and that impacts your health and welfare, that's sufficient. That alone is sufficient to state a claim. And that's applying Rule 12b-6 standard as it's intended.
All right.
Thank you, Your Honor.
Mr. Goldsmith?
Your Honor, may it please the court. As a matter of law, appellants failed to allege facts indicating delay in adjudicating their investor visa petitions was so egregious as to warrant judicial intervention. And under Iqbal, there's a line that you have to nudge across from the mere possibility to plausibility.
Right, you're exactly right about that. But Mr. Goldsmith, it would be really helpful if you would sketch out for us your understanding of what the government system is, what the rule of reason is, how the caps interact with the first in, first out asserted rule that the government follows.
Yes, Your Honor. I will try to do so. Let me just say that these are issues that weren't exactly raised below and were not really fleshed out in the briefing. But I will try to address your contention, your question about how the caps work. So the availability of
or more broadly, if you could affirmatively explain what is the rule of reason, what is the policy that the agency follows with respect to this program?
Right. So in around 2000, when they were dealing with a backlog of these visa petitions, they sought to change how they went about processing these petitions to consider and to not just consider, but to focus on the availability of visas, because not all petitions have a visa number available due to these statutory caps, per country caps. Now, the visa bulletin and the allocation of visa numbers is handled exclusively by the State Department. So USCIS isn't directly involved in that. But they looked to the State Department to see and try to prioritize those petitions where, if approved, the person, their priority date is current, they could obtain a visa. So whereas before 2000, they looked at, it was basically grounded in first in, first out, they switched and have tried to take into account and to more than take into account, focus on visa ability and to consider that in trying to deal with this matter.
Is that by country?
Did you say they switched to more than take into account visa availability?
They're focused on, before 2000, it was grounded in first in, first out, and then they moved to visa availability.
I thought the department's position was that it was still first in, first out, subject to visa availability.
It combines both. Your Honor is correct.
So what about the way the appellants have described the program is wrong? They say, when a country has reached the cap, set that aside and don't insist on chronologically processing the applications from those countries, because even if the application is fully processed, there's not going to be available visa. So set those aside and then do the rest of the world chronologically without regard to where the applications are coming from. And then if another country reaches its cap, set it aside. That is how I take it. Their understanding is based on public descriptions by USCIS. Is that not your understanding of what the rule of reason is?
I'm sorry, I don't have an answer to that question other than that this was not the issue that was litigated, other than to say they describe on their website how it operates.
I took this to absolutely be the issue that was litigated. It was described as first in, first out, subject to visa availability.
Yes.
That's what I understood
Right, yes.
complaint to say. That's
Yes.
what I understand the district court to have accepted. That's what I thought I may have a different view from my colleagues about judicial notice, but it's pleaded that that's what your policy is. And you're saying, no, actually, first in, first out isn't the primary guiding principle. It's now visa availability. And can you describe what you mean when you say?
I was not very clear, and I apologize to the court. There was an allegation that it's done in strictly first in. That's not correct. Look at visa.
How so? Can you give an example of putting aside India and China or any other country that has met its cap?
Mm-hmm.
How, in doing first in, first out, would the staff take into account visa availability?
Your Honor, that's the question I don't have an answer to. And
that seems pretty important. You don't know actually what the rule of reason is.
Not beyond what they said on the website.
And your understanding of what they said on the website is, again?
That they basically do things in, first out, with taking into account the availability of visa numbers. Now, there was this situation for approximately 9 months where they didn't have the authority to approve petitions in connection with the regional center program. So they didn't just sit on their hands. They adjudicated petitions that were called standalones that were not part of the regional center program. So I guess you could have a situation where someone filed later who got adjudicated earlier because of this circumstance. And there also are situations where there's a procedure where you can request an expedite. But I think Judge Boasberg hit the nail on the head where you said that you can't now complain that some other petitioners benefited from this process when the appellants in this case never sought to use this expedite procedure, that there aren't facts to connect what, the contention that there were erroneously approved expedite requests.
Can I go back to what the websites say about the rule of reason? Because there is a website that says there's an annual per country allocation of EB-5 visas. This is, I'm trying to tell you what I'm looking at. It's a website that says USCA suggests process for managing EB-5 visa petition inventory. And if you go to that website, it does say there's a per country allocation. And I think what Judge Pillard is interested in, and I am too, is if you go to the page about visas, it says 2 countries have met their cap. And the question is whether there's sort of still a country by country cap, or is everybody else lumped together in a FIFO system? And this website suggests that there is still a per country allocation. Is that true? So that in order to allege that you're not following your rule of reason, somebody would have to allege that somebody from the same country has been processed before them, even though they filed after. That's kind of what I'm interested in.
And again, I have to apologize to the court. I don't have any answer to that question. I don't think it was raised to raise this distinction between the two. And I apologize, I should have an answer. I would also like to point out that although there's no bright line rule, district courts have found in this circuit that delays of 5, 6, 7 years are generally unreasonable. But here we have delays of less than 3 years between when the petitions were filed, November 2019, and when litigation commenced, and that for approximately 9 of those months, USCIS allowed congressional authorization to approve petitions. And they've
Can you address the blanket expedites?
yes. So
That's not part of the rule of reason. So if there were blanket expedites, that would not be following your rule of reason, correct?
So there's currently no such thing as a blanket expedite. There's a procedure for requesting expedites. They're raising allegations as to that they were improperly granting requests to expedite 2017 in connection with an equestrian center or a international horse show in 2018, and that the effects of those continued on through 2019. And the question of whether or not they were properly granting these expedites, I think has nothing to do with whether or not they're entitled to a judicial order.
So your friend on the other side, I thought, said that expedite was in effect through 2022, or somehow it did affect his client's place in the queue.
I don't think there are any factual allegations to connect those allegations to these particular petitions. And I don't believe, for the reasons Judge Boasberg outlined, that the question of whether or not they were properly granting expedites, or whether some of the expedites should have been granted, but other later ones shouldn't have been granted, are a basis for awarding judicial relief to these with respect to these.
Would you agree there's sort of a legal theory issue and then there's a factual allegations issue? If there were, I think it would be a sufficient legal theory to say that you're saying you have a rule of reason, it's FIFO subject to visa availability, but the agency is actually doing something that's not subject to the rule of reason, which is taking a project and expediting all the EB-5 applications associated with that project. That would theoretically state a claim, but if there are no factual allegations to back it up, then that complaint would still be dismissed. Do you agree with that?
So I agree that there's no factual allegations to back that up. I would ask the court to consider it.
But what's your answer to whether that theory would be sufficient?
Perhaps not, based on this court's precedent in Citizens for Responsibility and Ethics in Washington v. Trump decision from 2019. It was a mandamus case in which this court held that a district court may properly consider a memo on its website at a motion to dismiss stage, citing Iqbal, even though the very fact that there's a memo, there's a policy, doesn't guarantee that that policy is being followed. And the reason is that plaintiff must plausibly allege that the government is defying the law.
But isn't that in tension with your position that what is on the website is the rule of reason? You're trying to rely on what's on the website to say this is the rule of reason, this is what we do.
Correct.
And now I'm saying if you're not following that rule of reason, is that a basis to challenge you? And you're saying no, because we don't have to follow the policy. How can that be?
No. Of course, the government has to follow its own policies. If the government's not following its policies, that's a real problem. But it doesn't follow, what I'm saying is it doesn't follow logically that if they did something, they granted some expedites that they shouldn't have granted, that these, of the 13,000 plus petitions pending, that these 4 petitions then get ordered adjudicated.
But if you granted policies, blanket expedites that are in conflict with your rule of reason and it affected the petitioners by bumping them out of line, why wouldn't they have a cause of action? Because you're not following your rule of reason. So you can't rely on that rule of reason if you're not following it.
Well, the fact that particular adjudicators may have made mistakes, granted a request for an expedite under the agency's policy, it should not have been. That by itself is not enough to in our view.
Is it not? I mean, so they don't have access to information. Mm-hmm. I take it saying there is a FIFO policy subject to caps. One assumes that that's first in, first out, there may be various other carve-outs, lawful or not, that have caused some later filed applications to be decided earlier. But assume each of those is either legitimate or just a done deal, still credit our use of FIFO subject to caps. And I think they're saying, well, why should we credit that if we hear about a lot of later filers who are getting approved, why should we assume your version of the facts, which is that, well, that was a horse show, and well, that's an abandoned policy that was authorized then but is no longer. Like they've raised some questions about the adherence to the rule of reason that the government posits.
I understand, but this court has said that the track factors are not clear. They are guidelines. They're the factors to guide the exercise of judicial decision. And here, Judge Boasberg said, even if we were to conclude that the delay was unreasonable, the balance of the factors still tip in favor of the government.
That is assuming that everything behind closed doors is proceeding with regularity.
Mm-hmm.
And we have other precedent that says, hey, when people aren't being treated equally, or when there's reason to think that stated policy is not consistently being followed, that's a different story. And so I think we're trying to understand whether the complaint has plausibly alleged a case that falls into that category.
Well, I see my time is about to expire. If I could just make 2 points.
Go ahead.
Thank you. One, we've never, what they seem to contemplate is some type of forensic style. We would go back and look at all petitions for X number of years, however many thousands, to determine which ones, when they were granted, and whether or not the government can prove whether it was a good reason why they were approved or adjudicated at the time. And this court has never contemplated that type of relief. But we're not writing on a blank slate. There's, of course, cases in district courts supporting the decision, two district courts here. And for those reasons, the district court decisions should be affirmed. Thank you.
Do you have any questions, Mr. Brown?
No, I don't think so.
Do you have any questions? We have your argument. Because you were out of time from the. Yeah. And does anybody have questions of Mr. Vance?
I'd be happy to hear a 1-minute rebuttal if you're willing from counsel.
Appreciate that. I'll be at 59 seconds.
Mhm.
So if you look at pages 8 through 12 of the government's brief, they describe the visa availability approach as I understand, and it's not by country. And our Mr. DaCosta always had a visa available, and so if they want to tell us that we're going to be jumping the line, but if they're jumping the line, it's okay. That's a plausible case. That is, if they want to rely on saying that if you grant relief, Your Honor, that you're going to be jumping the line, but they've already jumped it and they're not following the rule of reason, that's a plausible case for unreasonable delay under the Administrative Procedure Act. That's what we want. That's what we just want a day in court. Thank you, Your Honor.
Right, did you want to hear from Mr. Bannis?
1 minute.
Okay, 1 minute.
Thank you, Honors. If indeed the government's accurate, this is a line, then any blanket expedite that's unlawful pushes my clients back by definition, because it's a line. They're getting in front of the grocery store.
You just have to allege that there is a blanket expedite.
Well, remember, the blanket expedite was a one-time thing done in 2017 that extended all the way through 2021.
Why do you think it extended? Why do you think it extended to 2021? They said it was over.
The government's emails indicate that they stopped expediting these in 2021. And they sent out letters to investors who expected the expedite and said, oh, we're not doing that anymore. And again, Then you see, and then they want to do an investigation. They stop until the new administration came in, did an investigation, and wrote a lot of memos to try to protect themselves. And for that reason, there is no rhyme or reason to this process, and that's why we stated an unreasonable delay claim. Thank you, Your Honors.
Case number 22-1260, Intellistop Inc. petitioner versus United States Department of Transportation et al. Mr. Obermeyer for the petitioner, Mr. Ross for the respondents.
Mr. Obermeyer, good morning.
Good morning, and may it please the court. Again, my name is Steve Obermeyer. I'm representing Intellistop USA. With me is my colleague, Jeremy Brogy. I respectfully request 2 minutes for rebuttal. This court should vacate FMCSA's exemption denial for Intellistop's brake pulse module because the agency's decision is a textbook example of arbitrary and capricious decision-making. The record before the agency, including Intellistop's application, 5 government-sponsored studies and 2 private studies, 4 agency grants of exemptions for similarly situated products covering tens of thousands of vehicles, and 16 of 20 comments overwhelmingly support the conclusion that Intellistop's module would likely achieve a level of safety that is equivalent to or greater than the level that would be achieved absent such an exemption. Indeed, the record is clear that flashing rear lights generally and pulsing brake lights specifically substantially improve safety.
So the agency said there was a crucial distinction between your client's product and the ones they've approved before, which is that your client's product adjusts the existing brake lights, which are required from the manufacturer. And so the agency felt that there was not sufficient data to say that that was safe in case there was a malfunction. And why isn't that well-reasoned and a substantial basis to deny the application?
The problem with that, Your Honor, is it's entirely contrary to the studies on which they rely.
Well, I looked at the studies. The studies talked about the brake lights, but the issue that was, I should step back. I saw that the studies talked about flashing all the lights and how that could be good for safety. But I understood the agency's problem to be that the specific module that your client advocates is tied into the existing brake lights, and there could be a safety issue and there wasn't sufficient data that if there was a malfunction, the brake lights would still work, for example. And so I don't think that those studies address that specific issue about the module being attached to the existing brake lights.
Okay, so there's a couple of different things. First of all, the studies address, as I think you said, pulsing brake lights, not supplemental. Those studies alone, you look at the pictures, say, look at the picture on J.
But if the safety concern is about the method in which they flash, and yours is, the method is unique so far, like none of the previously approved ones. The previously approved ones were supplemental flashing lights. Yours, this is to my understanding, correct me if I'm wrong, yours are attached to the existing brake lights. And the safety issue is not about are flashing lights safe. The safety issue is yours attached to the existing brake lights. And if it malfunctions, we don't know if the brake lights are going to work. And that's very unsafe.
But
why isn't that sufficient? And it's not addressed by the studies.
But it is two separate. First is they're saying there were no studies that address pulsing brake lights, which are what my client's product does. That is unequivocally untrue. The 2009 and 2010 studies address the brake lights themselves. And as Your Honor said, in fact, that doesn't even raise the possibility, despite addressing almost a functionally identical apparatus, doesn't say, oh, and by the way, these things might fail. Let's move over to the failure point, which we argue is sort of an after the fact aside in one sentence.
It's right there in the.
Well,
Understood, Your Honor, but on the safety on that point, one of the issues is that all of the previous exemptions involved cutting into the brake circuit. They all are on the same, technically address the actual brake light. They don't distinguish why the Intellistop, which also does the brake
Where is it in the
lights, is somehow
record?
different.
Where is it in the record that the prior approved modules also tie into the same electrical system?
In those exemption decisions, they talk about it being brake activated, which is like a switch, but more importantly,
Well, that's
if you
different.
look-
That's different.
I'm sorry, Your Honor,
Of course, they're all brake activated.
but there's only one brake circuit, but regardless.
But where
if
is
you-
that? Where is that?
If you look at the addendum to our reply,
Mhm.
we have exemption requests for waste management and roads. And I think both of them, definitely waste management talks about it going into the brake circuit. They don't explain why Intellistop is put at a higher level of explaining why that would be an issue or why it wouldn't have been an issue previously, why it's never been raised as an issue.
so is there a study or exemption in a situation where the flashing is flashing of existing legally required brake lights?
Yes, sir. That's the 2009 and 2010 studies. And what I'd encourage is that you look at JA 181, the pictures, there's multiple pictures, but you look at the picture of the apparatus in those tests. And you look at the Intellistop video that was submitted with its application. It looks exactly the same.
So I think that the concern, at least as I see it, is that the agency says that Intellistop's application would alter the performance of the required lighting device and doesn't assert that if the installation malfunctions, that the brake lights would return to their best function. And in fact, stands to reason. They're talking about, 5-minute or 15-minute installation. If I went in and tried to install something on my car, the likelihood is that I might end up with no lights as opposed to wonderfully flashing lights. And so I think that's just intuitively the concern that wasn't addressed in the other devices that were exempted.
First of all, it should have been addressed because it's on the brake circuit, and that's one of the problems. That's a Burlington problem because it's disparate treatment without explanation. The other thing is, I think you said something that Judge Pillard, I'd like to correct, which is Intellistop said in its application, it will revert to the normal brake lights.
Right, but saying it and having evidence of why that is, it just, to me, intuitively, it is a concern. You're having, hundreds of thousands of enterprises around the country doing a retrofit.
All of these involve retrofit.
Yeah.
There are tens of thousands of vehicles out there already doing this with flashing lights. So, and this idea about a malfunction with respect to Intellistop comes out of thin air. I mean, it's not referenced anywhere. The representation is it works. There's a comment that says we had a failure. The brake lights did keep working. There's no evidence to support this.
Well, I guess it seems different to me to say I'm going to add something on versus I'm going to deploy the required system in a new way. Is that a meaningless distinction in your view?
I don't know whether it's meaningless or not because the previous exemption requests involved altering the current system, right? Because they're on the brake circuit. There's no distinction about the brake lights being affected between ones that have been granted and Intellistop's which was not granted. That's a fundamental problem. But I want to go back.
Let me ask you about growth, because I've got it in front of me. First of all, it's not supplementary for those 2 seconds that the flashing, and that brings up another point as far as distraction. If those things are flashing only 2 seconds, you could be looking over here and you wouldn't even see it. So I don't think the driver confusion or distraction is that big a problem. But these other growth and waste management, they're up at the top, they're over here. Meanwhile, I mean, the brake lights are on, the steady burning. These are going on all over the place. And that's, as I understand it, completely different from your product, that you would, with the brake lights down at the bottom, they would flash for 2 seconds. and then steady burn. Am I wrong?
With one small correction, which is that the back of a tractor trailer has one of the top lights as well, sort of like you would have in a car. So if you look at the apparatus in the testing, there's 2 brake lights and a light above. It's like the CHMSL. I always.
And that's the standard required, yeah.
Right. So then a tractor trailer, Your Honor, with our product would be flashing that as well, the same.
Okay, so it's going to be flashing up here for 2 seconds, flashing here for 2 seconds, and then steady. But the Grote has got, according to these, has got flashing, in these 5 options, has flashing lights here, has another one in the middle of the brake lights here. I just think it's, unless I'm misunderstanding how your product works, these are just different from yours.
Well,
First of all, they're supplementary.
They're absolutely different in that respect.
Well, that's.
But what I'm saying, Your Honor, is the fact that they're supplementary doesn't address the 2 issues. The 2 technical issues are, was there ever a test that addressed pulsing brake light? The answer is yes. The agency's decision is centered on saying no. It's actually totally backwards. Those 2 tests form the foundation of the waste management and growth decision.
I thought those tests were of cars. I looked at one of them, and of course, you've got a window, and a big light here. Did they ever do tests of trucks?
Not that I'm aware of, Your Honor, but those tests of cars, if you look at the waste management and growth decisions,
Right.
those tests are sufficient to conclude that those exemptions would be granted, and they are less like those products than they are Intellistop. It's totally backwards. They rely on a flashing brake light apparatus to grant exemptions for supplemental lights, then come back to Intellistop and say, we're going to treat you differently because you're not supplemental. It's totally backwards. And again, I keep up with the pictures, but the pictures show it plainly when you put the picture of the test apparatus next.
Well, if it's not backwards, if they're also saying, and we don't know that if it replaces for those 2 seconds the steady burning brake lights, we don't know how that affects the functionality of the steady burning brake lights. And that's, to me, a pretty important safety.
But they didn't test that of the previous products, Your Honor, that also go into the brake.
That's because they didn't. That's because, as I understand it, the steady lights were always on. It's these flashing ones that are supplementary to it.
But the issue that they're raising with Intellistop is that a failure would somehow affect the brake.
I think they're raising 2 issues. They're raising one issue, which is visually, it's supplementary as opposed to replacing. So it's a visual, it's a sort of, different kind of warning apparatus. And then the other issue they're raising is, and once you're getting into deploying the existing required steady burn lights in a non-steady way, if it malfunctions, is it going to revert to steady? Is it going to revert to always flashing? Is it going to revert to black?
But the problem is, this is why I say it's backwards. The supplemental light decision is based on the flashing of only the brake lights. That's what that apparatus is. They cite the 2009 and 2010 studies that are about something totally different.
But those are studies. Those are not exemptions. And, they're part of the universe of information, but that doesn't mean that by the existence of that study being out there, that the agency is necessarily persuaded that it's enough.
No dispute, but those studies were said to be sufficient to conclude that 2 previous exemptions of products that were less like those studies.
I'm sorry.
Would be granted.
But that also had more belt and suspenders, arguably, in the agency's view, because they had the steady burn lights and supplemental lights.
But the testing of the supplemental lights, that's not in those decisions. And there's not even a test that does supplemental lights like those products. The 2014 test, the only supplemental light study, the 2014 study, the only supplemental light study is a radar activated. It's not even brake activated. They're basing their decisions on these. The studies are more different than those exemptions than they are for Intellistops. We get denied, they get granted.
Right, but I think they're saying, okay, the studies show some stuff, but the exemptions that they granted don't go as far, either substantively or in terms of volume of trucks involved. And they're just saying it's step by step. It's just a little bit more of a leap. Conceptually, there's a lot in common, but it's a little bit more of a leap to grant exemption to your client than the prior parties.
I respect.
Can I please
Oh, sorry.
interject here? I'm looking at the actual decision here, and I want to put aside the issue of do flashing lights promote safety, and just look at the method with which your module does it. And it says, importantly, all other pulsing rear light exemptions that we've previously granted involve the addition of non-mandatory auxiliary lighting systems, whereas Intellistop seeks permission to alter the functionality of original equipment manufacturers' lamps, which are covered by an existing FMVSS. The agency believes this is a crucial distinction and one that TSEI highlighted in its comment. And then it says, the agency, in consultation with NHTSA, has determined that it does not currently have data to support a blanket exemption for industry to alter the performance of a required lamp covered by FMC, SRs, and FMVSSs. So putting aside that flashing lights are safe, the problem is with your technology that messes with the required brake lights.
But they're mistakenly saying, Your Honor, that there's no evidence that that flashing brake lights have been produced. The 2009,
No,
2006.
I've asked you to put that aside. It's not about flashing brake lights. It's about a technology that messes with the existing brake lights and doesn't just add new flashing brake lights.
And on
That is what they're saying. There's no data.
And on that point, Your Honor, the previous exemptions all involve messing with the brake lights, however you want to say it, based on, they're also.
And where in the record is that?
In the addendum to our reply, which is one of the applications, which is part of the record. It's in the waste management and the growth applications, but all four of
Okay,
them.
I don't think you've briefed it this way.
I'm sorry, Your Honor? We didn't.
I think that your briefing is focusing, as you're trying to focus on in your oral argument, about the fact that flashing lights are safe. And I don't think that, I haven't seen in your brief an argument that addresses the actual lack of data about the technology that goes to your brake lights. And that that is something that's different, that you've been treated differently because their technology also is attached to existing brake lights. I don't see an argument like that in your brief.
I believe it's in a reply. I will check before I come back up here, but
Okay.
we absolutely address the issue because the government focuses entirely on this. Despite
You said you were addressing in the addendum to your reply, but not in your opening brief, despite the fact that this was as Judge Pan was reading from JA 23, this is the differentiation between this exemption and other exemptions.
Well, Your Honor, that's because the decision says it's based on three things that are not the issue of the failure. We address it in the footnote in the opening because it was an aside in the opening decision. When the government in their opposition says it's really all about a malfunction, we address it in the reply because it had shifted the whole focus. The centerpiece of the decision is an absence of data on flashing brake lights, which is contrary to the record. That alone is a vacate. Because they're misleading with the studies, Your Honor.
And if we don't agree with you that this whole opinion is about flashing brake lights, we think it's about the technology, then you lose?
No, Your Honor, for the reasons I've already said, which is it's still a Burlington issue where it's disparate treatment without explanation because the previous products involve going into the circuit as well. And also, I would
Which you didn't raise till your reply brief.
Pardon me?
But you didn't raise that till your reply brief.
No, I believe we do, Your Honor. I believe, but again, I'll check again, but I believe we do.
I
mean, we say
think
it's
you have to
treated
raise that in your opening brief, though, in order to preserve it, don't you?
Not the issue here, Your Honor, is that again, this was an aside in the original decision about in the exemption decision about this issue. We raised it in a footnote.
So I'm not focusing on the malfunction part. I'm focusing on the part I just read to you, which is the agency in consultation with NHTSA has determined that it does not currently have data to support a blanket exemption for industry to alter the performance of a required lamp covered by the FMC, SRs, and FMVSSs.
And I would say we address that head on by addressing the fact that the studies do address it. The 2000.
They don't address a module that changes the existing brake lights. Your studies talk about flashing brake lamps. That's different.
The study, but necessarily that apparatus has to be addressing the.
But it's talking about the safety of flashing, not the safety of the technology at issue.
And the important point to this, Judge Pan, which we also say in our reply, is that none of the previous exemptions were evaluated on a technology-specific basis. If you look at the explanations that
Because they were auxiliary, so the existing brake lamps, which are required to be steady burning, are still there and steady burning.
But it's applying a different standard to us that we couldn't possibly have known based on the 4 previous exemptions. We gave more information. We have a video that shows exactly how it goes in. A 3-minute 50 video shows exactly how it attaches. There is evidence in the record that a failure is not going to result in the brake lights going out. None of it's addressed. And that evidence, I would add, Your Honor, that's the Tankstar comment. The Tankstar comment is addressed in the decision. It didn't even mention the fact that there was a failure and that that the brake lights would turn to normal off. Unless you have any other question.
We'll give you a couple of minutes to reply.
Thank you.
Thank you, Your Honor. Cason Ross for the United States. I think it's worth turning to the text of the statute in this circumstance. 49 USC 31315B requires an applicant for an exemption to an existing regulatory standard to demonstrate that the sought-after exemption will result in an equivalent or greater level of safety. And even if the applicant makes that showing, the agency might, in its discretion, decide to deny the exemption, of course, subject to reasoned decision-making. FMCSA reasonably concluded here that Intellistop's spare factual showing, both with respect to its particular module and with how its module would interact with driver confusion and distraction in a wide-scale implementation, reasonably denied that application. All of the other exemptions that Intellistop cites here were either much more limited in scope or addressed auxiliary brake light structures, such that they wouldn't have interfered with federal motor vehicles.
They supplement steady burning brake.
They supplement, correct. None of the other exemptions were to replace existing brake light functionality. And that's why the agency needed to consult with the National Highway Safety Transportation Administration, or NHTSA, because that operating administration within DOT oversees the motor vehicle safety standard.
Do all these flashing lights that you have approved, do they just flash for 2 seconds?
I'm not sure of the exact timeline, Your Honor, but they're all, I think, in relevant respect, similar to Intellistop's with respect to the flashing. But
to the time?
I think so.
Okay.
But they all are supplemental.
I realize.
And that's an important distinction as the agency's decision.
Is it? I mean, one of the, the questions about whether it was promptly briefed, but Mr. Obermeyer has said that, any brake activated light has to integrate with brake circuitry. So if there's a short or if there's, some failure to really do that well, presumably it would have the same concern that a malfunction might not leave the statutorily required steady burning lights in working order, might leave us worse off than we started.
So in my quick scan of the addendum to the reply brief, none of the other applications for growth industries and waste management specifically hone in on this fact. And
I think the only thing I saw was where the Grote refers to it being on the brake circuit. It's just part of the bring your attention to your equipment. Lamp works on brake circuit. That's the only thing I saw. But it stands to reason that if you're wanting to activate it with the brake, that there would be some involvement. I mean, I don't know, maybe not. Maybe you would have a little push button under the brake.
Frankly, Your Honor, I'm not sure because I think you're right that this question wasn't directly briefed. It is worth noting that a malfunction in the case of a supplemental light versus an existing brake light is much more serious with respect to the latter, because if a vehicle's sole brake lights stop working, that is significantly less safe, as the agency explained here. And I'll also note that I believe Your Honor was aware of the fact that the agency was encouraging an incremental approach. And FMCSA, actively encourages the development of new safety technology in order to make America's roads safer. And that's why, in this particular case, it encouraged individual motor carriers to apply for exemptions to use Intellistop's device. In my understanding, this is not in the record, but the Federal Register notices have been published, is 7 motor carriers have applied to use Intellistop's device. And Intellistop itself is advertised for that possibility. And the agency is reviewing each of those applications in due course. There's currently under consideration, but in this particular case, for an industry-wide exemption, which could apply to hundreds of thousands of motor carriers, the agency reasonably concluded that a more incremental approach would be appropriate.
And so tell me about that, because their position on that is, look, if it's safe for one, it's safe for all. And, and you say, well, all is a lot and let's be incremental. That there's some logic to that. But is there also behind the prospect that there might be exemptions for this very technology granted to individual firms that would prioritize firms with sort of sophisticated engineering capabilities, as opposed to, like, I have my semi out and back and I'm going to go to the AutoZone and buy this and do it on the weekend? Or, is there something about the review of the companies and their capabilities that figures into this? Or, like, spell it out a little more if it's the exact same technology.
Sure. So I don't know, frankly, how the agency reviews each specific company, but I think with respect to this application, there are 2 reasons why FMCSA determined that denying the exemption would be proper. The first is that there was no evidence presented on how wide-scale implementation of this particular device would affect driver confusion and distraction. I believe Judge Henderson seemed to hone in on this fact, which was that if all of a sudden, all of the semi-trucks on America's roads are blinking their lights rather than steady burning, then all drivers, I think, might be confused, or at least the agency explained that there wasn't sufficient data to demonstrate that they wouldn't be confused. So at minimum, it was not arbitrary and capricious for the agency to rely on that lack of understanding with respect to wide-scale implementation. The second, and this gets a little complicated, and I apologize, but because this particular exemption involves a motor vehicle safety standard, which is that all motor vehicles have to have steady burning brake lights, that's why the agency had to consult with NHTSA on the availability of this exemption. And 49 USC 3122 includes a provision that manufacturers and repair people, certain entities cannot, quote, make inoperable certain components of a manufacturer vehicle's, components. And if the exemption was granted on an industry-wide basis, the agency reasonably concluded, again, in consultation with NHTSA, that it wouldn't be able to monitor how the devices were actually installed. But if the agency grants individual exemptions to particular motor carriers, there's a greater assurance that the device will be installed correctly and by the appropriate people. And then I think it would also be—
So that I couldn't put this on my own truck if I had.
You could. That's actually what the Motor Vehicle Safety Act requires, is that the owner of the vehicle would put it on their vehicle. Right.
Okay, I
but
got it.
not exactly. So, but that makes a lot of sense, right? So that a vehicle repair person wouldn't be able to make inoperable a component of your car, unbeknownst to you. And so then it's limited to the owners themselves.
So what about Roche? Because they also got an industry-wide exemption. And when the agency gave them the exemption, they said interested parties possessing information that would demonstrate that motor carriers are not achieving the requisite statutory level of safety should immediately notify FMCSA.
Mm-hmm.
Why couldn't Intellistop get the same type of treatment as Roche?
So for what it's worth, that sort of disclaiming language is included in all granted exemptions, because the agency has a statutory duty to revoke exemptions if safety is not maintained.
But was Roche industry-wide?
Yes. But the main distinction with Roche is that it's supplemental lighting, not the required lighting. And the agency, I think, reasonably concluded that because it was only a supplemental lighting, that the safety impacts from that kind of more broad exemption didn't implicate the same concerns as Intellistop's did here. And I think this sort of dovetails with the malfunctioning concerns with Intellistop's particular device, as well as possibilities for confusion when implementing on a wide-scale basis. I
And
think
when they granted GROT, had they already granted other exemptions of auxiliary flashing lights?
I believe so. I forget exactly the timeline. All of the granted exemptions are in the administrative record for waste management, the national tank truck carriers, Groendyke Transport, and GROT Industries. And the point I was going to make was with respect to Judge Henderson's concern of supplemental lights versus your existing brake lights flashing. I think the agency reasonably determined that if there are flashing supplemental lights, that would cause less driver confusion than the existing brake lights flashing, because the driver might reasonably find that as long as there's a sort of a benchmark, right, of your existing brake lights steady burning, then that's what we're accustomed to as motor vehicle drivers, rather than some other flashing lights. Sort of similar to how bumper stickers on your car are unlikely to distract you, as opposed to putting a bumper sticker on a brake light itself. And so if you're interfering with the required safety components that the NHTSA and other agencies have mandated, the agency reasonably concluded that that's a meaningful distinction and that a more cautious approach would be required here. And this court has regularly held as much. In American Petroleum Institute, the EPA, the court has urged caution when safety determinations are at issue. And so there is some level of deferential gloss to the agency's arbitrary and capricious review that would cause or would urge the court to deny the petition for review here.
So I think that there is a misstatement in the agency's decision where it says generally Intellistop relied on studies of other lighting configurations proposing to add additional pulsating lights.
Mm-hmm.
And that's at JA 23.
Mm-hmm.
But if you look at the studies, the 2009 and 2010 studies, they just have simultaneously flashing lights and not necessarily auxiliary. What do we do with that mistake?
I think that's right, Your Honor, but that actual mistake in the agency's decision is no basis to vacate it.
Isn't it an error if it says generally they relied on?
Say again?
I mean, one could just put the emphasis on generally they relied on.
Oh, that may be the case. I was merely conceding the point to Judge Pan that sort of factual inaccuracy, if anything, is harmless and is not the bottom line to the agency's decision making. And in fact, on JA 22, it's the bottom full paragraph of the third column. The agency expressly explains how data deficiencies in each of those studies led it to conclude that whatever conclusions could be drawn from them, which I will reiterate are necessarily circumspect and hardly conclusive, and in all circumstances, even in the 2009 and 2010 studies, encouraged wider scale implementation and much broader so-called fleet testing before any definitive conclusions could be drawn from the studies themselves. But on JA22, the agency explains why data deficiencies in the studies caused significant concern here, where it may not have with respect to, for example, GROT Industries, because it didn't implicate a motor vehicle safety standard.
We've had a long morning, but I just want to ask, is the school bus the only vehicle that has flashing but alternating flashing?
I think so, Your Honor, but I'm not positive.
Okay.
Yeah.
We've been talking about these lights for days, and I thought that's what makes the school bus so
Distinctive.
distinctive is it's the only one that's.
Well, emergency vehicles also have flashing lights.
Right.
Yeah.
Okay.
And that is, for what it's worth, that was also part of one source of the agency's concern, and part of one of the commenters' concerns is that the color of the lights could also cause driver confusion, especially if they're flashing in different places. All of this goes to show that these kinds of safety determinations are best left to the agency's technical expertise, and the court should defer to those determinations.
All right. Any more questions?
We urge the court to deny the petition for review.
Thank you. Mr. Overmeyer, why don't you take 2 minutes?
Based on that long morning queue, I will only take 2 minutes. The first most important thing I would say is I think I just heard the government concede that there are incorrect statements about the record in the decision. They said, and I'll read one of them here. It's, generally, Intellistop relied on studies of other lighting configurations proposing to add additional pulsating lights. They have misrepresented what the studies say. That alone is a vacate. That's National Fuel Gas Supply Corp. There are multiple reasons for a denial that are not dependent on each other. Then vacate is what has to be done. So that alone gets us to a vacate. I think that's a very important point to point out. Another thing, there was some questions about where the issues were raised on the briefs.
I'm sorry, I thought that the standard is we would vacate unless we are certain that the agency would have adopted even absent the flawed rationale.
That's correct, but it has to do with whether the reasons are dependent or independent. Here, the reasoning is dependent because this is the foundation of the rest. So for instance, Judge Pan, with respect to the module malfunction, that sentence I read is the sentence that immediately precedes the malfunction sentence. So the foundation of even the malfunction sentence is based on a mistake in what the studies actually said. So I think that's a vacate issue. There was some questions I want to answer for you, Judge Pan, about where things were raised in the brief. The issue about Intellistop not providing enough information is raised in footnote 4 of the opening brief. And it's a footnote because I would continue to argue, I don't know that everyone here agrees, but I would continue to argue it is a footnote point in this decision. And if you look at the decision, the safety analysis, the statutory analysis that's required, that section never mentions the malfunction. So I think that's an important thing. And the last thing is there's some talk about scope. And Judge Pillard, I think you had said there were no, I think this may have been corrected, but growth is absolutely an industry-wide exemption. There's no evidence in the record that flashing generally is an issue. In fact, it's been the opposite. They would have to pull the exemption if it was causing issues. So there's no reasoned decision to treat those separately. We would ask that the court vacate the exemption. Thank you.
All right, thank you.